Good afternoon, everyone. My name's Stephanie Hope and I'm the Senior Associate Family Lawyer at Argent Law in Richmond in Victoria. This afternoon I have joining me Larissa Goldberg of Goldberg Family Law Mediations in Caulfield, Victoria. We're here today to talk about family dispute resolution conferencing, in particular the role of family dispute resolution practitioners, or FDRP as they're known in the family law industry. So welcome, Larissa. Thank you for joining us today.
Thank you for inviting me, Stephanie.
Larissa, what is the role of an FDRP?
An FDRP is a type of mediator. It's an independent person who helps people affected by separation and divorce to resolve disputes, including parenting and financial.
Now, that doesn't sound that complicated at all. Why the complicated name? So what are the qualifications that you hold to be an FDRP?
So to be an FDRP, you need to be accredited by the Commonwealth Attorney General's Department, and FDRPs are the only people who can issue what's known as a Section 60I certificate that would enable a parent to make an application to the court for a parenting order.
Right. Does that mean that this process has to be undertaken before you can apply to the court?
In most cases, yes. There are exceptions there. It is not compulsory to attend family dispute resolution, though, for financial disputes, and a certificate's not required for that.
Right. And are there any exceptions to participating in family dispute resolution conferencing, even if your focus is on parenting disputes rather than property, if you have some concerns about participating in the process?
Yes, and those concerns the practitioner will address with each party during their individual intake for the process, and then the practitioner needs to assess, going through the requirements of the regulations, whether or not it is appropriate for that situation.
Right.
So if it is assessed as not appropriate, for instance, due to the extent of family violence or child abuse, then they can issue a certificate to that effect that would enable the parent to go directly to court.
Right, and I guess the lawyers who are advising family law clients also advise them on whether or not it's likely that they will have to participate in an FDRC with someone like yourself.
Yes, it is possible for a lawyer to make an application on their client's behalf to waive the requirement to attend family dispute resolution.
Right. And just thinking about that, some of the situations where people might want to be excused from participating in a conference is cases of urgency. So how quickly can an FDRC be organised?
It depends on the provider. Larger organisations like not-for-profit organisations, government-funded organisations often have waiting lists.
Right.
They also have a requirement in government-funded centres to attend an information session, which adds an additional layer to the process. If the parties both agree to attend, that's clearly going to speed up the process. Private practitioners can generally accommodate clients' personal and work commitments better, and often see clients outside of business hours.
Oh, fantastic. That would really benefit a lot of people. Do lawyers participate in the FDRC process?
They can. It's called legally assisted FDR, and if agreed by both parties, one or both can be legally represented. It's also open to the parties to take a break during a conference and call their lawyer to obtain advice. So rather than having their lawyer there the whole time, they can call and get the advice that they need at a particular juncture, and that can be more cost effective for them.
Right. Might be a good idea in that circumstance to let your lawyer know when the conference is taking place, just to make sure they can take your call.
If that is the case, I'm generally careful as to whether or not we schedule anything on a weekend or outside of hours.
Right. And so what's the average length of a conference?
It depends again. So the larger organisations often have a fixed time of 1.5 or 2 hours. With private practitioners, mostly set a conference of 2 to 3 hours. Because I only schedule one conference a day, then I can extend the time if the parties wish to continue beyond the allotted time.
I suppose if they're making good progress, you want to continue. What about having a mediation for both parenting and property? Is that possible?
Yes, it is. Yes, it is. But because financial is voluntary, I recommend that the client first get the agreement of their former partner before they embark on the process, especially if it is for property only.
And what are your tips for organising an FDRC? What do the parties need to know before they come along to have the conference with someone like yourself?
I like my clients to do a lot of preparation. I give them a lot of homework, checklists and information. The focus, especially with parenting matters, is prioritising the best interests of the children, considering what their children's needs are, separate from their own needs. With financial mediations, the focus is just an equitable resolution that takes into account the way the Family Law Act focuses on property settlements.
Right. So it's often a good idea for people to get legal advice before they participate in an FDRC?
It's not compulsory, but I recommend that all clients obtain legal advice from an experienced family lawyer before they embark on the process, during the process, and also, most importantly, before they sign any legally binding document.
Well, that's my next question. Can you write up the agreement, and will it be legally binding if people will simply come along, see you, they resolve all their disputes regarding parenting and property? Are orders then automatically made?
It really depends on the parties, and again, I recommend they get legal advice about the options available to them. So after a session, I will type up a summary of what has been agreed during the session. The parties have the option to turn that into a parenting plan, which is a legally binding document. I can prepare that, all lawyers can prepare that. If they're wanting to have orders made by consent by the court, then the lawyers will prepare those documents.
Fantastic. And the discussions that are had in the conference space, can the parties then rely on that in court and tell the judge what was discussed at the mediation regarding parenting or property, and use that as part of an application in court if things aren't resolved?
No. Anything that is discussed in a conference with an FDRP present is inadmissible in any subsequent proceedings. There are exceptions, for instance, if a threat or there was a risk of harm to a person or property. But otherwise, the general rule I tell my clients is what happens in FDR stays in FDR.
I can imagine. All right, that's wonderful. Now, how can people contact you, Larissa, if they've heard what you've had to say and they know, or their lawyers have advised them, that FDRC is the way to go for them? How can they get in touch with you or other FDRPs?
So there's Family Relationships Online is a good starting point. There's also a link there. There's a register of accredited FDRPs that is maintained by the Attorney General's Department, and there are links to various government-funded not-for-profit organisations. They can also Google Family Dispute Resolution. Will bring up a lot of their nearest providers. I can be located either Googling my name or Goldberg Family Law Mediation. I have a website with a lot more information about FDR, a LinkedIn page, and also a business Facebook page.
So all those people can get started on all that homework you're going to put them up onto. Well, that's it for me today. Thank you so much for giving me all this valuable information. I'm sure our viewers will have gotten a lot out of your talk today. So once again, this is Stephanie Hope from Argent Law with Larissa Goldberg of Goldberg Family Law Mediations. Thank you for watching this video, and down below we'll have the contact details for us at Argent Law and also for Larissa.